The Attorney General Kiryowa Kiwanuka yesterday told a joint meeting of state prosecutors and crime investigators at the CID headquarters in Kibuli that he is opposed to provisions of the law warranting courts to acquit suspects who proved to have been tortured in detention and during interrogation. He suggests that this is a miscarriage of justice. We are joined by Counsel George Musisi on NTV at 1 to elaborate more on this matter. Good afternoon to you, Counsel.
Good afternoon.
Now, first of all, we'd like to have your opinion and translation of what the Attorney General did say.
Of course, the law as it is now, the Prohibition and Prevention of Torture Act, says that if any person is charged with whatever offense and he proves to court or she proves to court that they have been tortured, then, and indeed court ascertains that there's sense and this person was tortured, is supposed to be let go. The charges are supposed to be dropped, and it doesn't even classify what kind of charges. That means that even a person charged of, say, terrorism, if it's proven that they were tortured in the course of either the arrest or the detention before production in court, that they're supposed to be let go. And the Attorney General is disagreeing with that, saying that it's a miscarriage of justice.
All right. So what would constitute proving that someone has been tortured? What would the court accept?
Of course, court is supposed can carry out either an inquiry on its own. If a person raises these allegations, court can carry out an inquiry of its own. If it's a magistrate court, there's a provision for it to refer it to a higher court. And of course, the background is that torture is a non-derogable right. Torture is not allowed under any circumstances, no matter the gravity of the charges the person is facing. So if court indeed is satisfied either on the face of it could be, say, you have torture marks all over you, which were not with you when you were arrested, or after an inquiry of its own, say, medical evidence, then court can let you go.
Okay, looking through the histories of law and justice in this country, do we see cases where people have actually been acquitted on the account of torture?
Yes, there have been not so many, but it has been raised in some instances. And then in other instances, it hasn't been raised, but it's there. It's the law, actually, many times.
So, yes, the law is there, but has that law, part of the law, been implemented?
Yes, there have been one or two cases where people have been let go on the basis of that, law, and on the basis of how they were treated in the course of the custody. And for me, I would rather look at what was the purpose of the lawmakers. It was to send a strong message that torture is not allowed, no matter the charges the person is facing. This person, of course, because it's on the background that we have a presumption of innocence, that even if you are facing whatever charges, there are still allegations which the state has to prove. So a person shouldn't be tortured because he's facing very grave charges. So yes, there have been instances where, not so many, but a couple of cases where indeed courts have let people go on the basis of how they have been treated in custody. What
are your personal sentiments towards the Attorney General's comment?
One, what was the purpose of enacting that law? Because it's a relatively new legislation. It's not even slightly less than 10 years old. And yet the Constitution in 1995 put a strong prohibition against torture. Of course, coupling down from international standards and then bring them down. And torture is one of those rights we call non-derogable, meaning that even in times of war, it's not allowed. So the purpose of the law was to ensure that state actors, especially state actors, respect the rights of even suspects, not to torture. So now we brought that into a law, which has not, you've asked me a few minutes ago that how many cases, and there have not been so many where it has been put to play. That means that even the full efficacy of that Prohibition and Prevention of Torture Act has not yet been achieved. So by the AG coming out to say that even this one, which has not worked so well, we should amend it, I think it goes against the fight that was intended, because the fight was intended to send a deterrent message to state actors that torture is not allowed. And one of the things was saying that if you torture a person, the court might let him go on the basis of that torture. So I think the AG's remarks may be seen as being encouraging those people who torture.
Okay. All right. Thank you so much, Counsel George Musisi. And that brings us to the end of that conversation with him. However, in our newsroom, it's still a building story that will have a full report in our subsequent bulletins, NTV Kusawemo and NTV Weekend Edition. For now, NTV at 1 continues shortly right after this.